Next matter to come before the court this morning is Aladdins Lights, Inc. versus Lighting International. We are a couple of minutes early. Are we expecting anyone else this morning for oral arguments regarding this case?
No, Your Honor. No, Your Honor.
Each side will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. I'm keeping the clock this morning, so if you would like to reserve some time for rebuttal, if you let me know when you get started, I'll keep you apprised of the passage of time. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. May it please the court, counsel, I'm Tom Lapp here representing the appellant, Aladdins Lights. If I may reserve 5 minutes. This is I'd like to say it's a fairly simple case, which is what I always like to say at the beginning of anything. But I don't think I'm going to say that today. I think the dogs and the checks might have been easier. But I mean, this case, from a legal standpoint, what we're looking at is an antitrust case. We're not looking at a Sherman antitrust case. We're not talking about federal law. We're talking about the state law of the Ohio Valentine law, which is fairly distinct in itself. Basically, what we're talking about is a situation of lighting. We have the manufacturer of the lighting, iLighting. They have some parties in between who are not actually parties to the case, were never involved in the case, and then my client, who is the ultimate buyer of the property, and he's a retailer. What we have is something that for well over 100 years, or close to 100 years, under the old Sherman Act, would have been considered to be illegal by any standard. And that was price fixing, minimum price fixing. That changed at some point in time, and is no longer per se illegal by the U.S. Supreme Court, and that's under the Sherman Act. Like I told you, we brought this action under the Valentine Act, and we think there are some slight distinctions there. We do understand, and I do recognize the fact that the Ohio Supreme Court has ruled on the Microsoft case, the Johnson Microsoft case, and that this case might be one, I'm not going to concede here today, but it might be one that we have to get through this appeal ultimately to get to the Ohio Supreme Court if that's what's chosen to do by either party. But quite frankly, under this, we have the issues, obviously, the price fixing, then we also have an issue of a discovery issue. If I could touch on the discovery issue first, I think it's an easier one to deal with very quickly. During discovery in this matter, after the time for producing documents was already up, basically 28 days plus some time was up. After that time, counsel for the defendant asked for some additional time, or at that point said, we need a protective order, we can't turn these documents over. We can't even provide these documents to counsel, but counsel can't show these documents to their client, and got into this problem of something called attorney's eyes only. Something that's fairly rare. It is kind of something a little bit more often being used. Basically, I'm going to turn these documents over to you. I'm going to try to get an order from the court that you, the counsel, are the only one who's allowed to see them. If anybody else sees them, you're violating something, they're violating something. You both have contempt issues as well as other issues. If you want someone else to see them, you have to come to the court, request permission for that, hold a hearing for your expert witness or anyone else. They then have to sign the documents, and they have to sign that they're not going to share these documents with anyone else, including your client. Someone who is integral in helping you prepare your case can never see the documents that are being used to defend against the case. The problem we have here with that order is the process wasn't done properly. The law in this area is fairly clear. If you're going to go to an AEO, attorney's eyes only, if you're going to do that, you have to go through each and every document that you're trying to protect. And the burden is on the party that's trying to protect the document to make sure that each one of those documents is reviewed by the court, so the court can make an individual decision. Here, that didn't happen. What we had was briefing on the issue in general. We had a hearing which was, to this day, amazing to me. It was in open court. I mean, if I'm trying to get something to attorney's eyes only the attorney can see, I'm asking the court to seal the courtroom. I'm asking the court, can we do this in chambers? I'm filing a motion on that.
Assuming all that was error, what's the prejudice in this record? What reflects the prejudice of that error?
The prejudice is my clients were not able to have an opportunity to review the documents to aid me in the prosecution of this case.
But that might get you the appearance of prejudice, right? But we
Correct.
don't know what's in the record about it had, I understand it's a discovery issue, we're not knowing at that point
Right.
what's going to be relevant, but
Right.
you have to show that did create actual prejudice, so where do we look in the record for that actual prejudice?
I don't think we get, I don't think, I understand I understand what you're saying. I think the problem is they didn't jump enough hurdles to get us there.
Well, I don't understand.
It was their obligation to present testimony, evidence, documentation on each and every one of these documents. Without having done that, there is no ability for me to show whatever happened. Unless I then ask the court to convene a hearing, and I want to go through every single one of these documents, and I want you to now rule on these again. It's not my obligation, it's not my burden. I can't be forced to do their job. I think this court has to send this back on that issue for the court to go back and then take a look at those individually, if they're still going to claim those are. Or the court has to just say, no, this is not, these documents, you did not meet your burden. These documents are now all open. Remand this case to the court, so we can then look at these documents with my client, sit down, and then re-review this. Quite interestingly, with respect to the summary judgment issue, this court, the trial court, had the same complaint, the same issues, the same everything, at the case very early on, ruled on a 12b6, or I think it was a motion on pleadings of sorts, and said, no, there's sufficient allegations here to go to trial. Then comes back and gives what I think was a 4 or 5 page summary judgment ruling, essentially saying you don't have sufficiency to go to the trial because you lack standing. And it really, those two don't go together. And I think that part of the reason that they don't jive is that the court that my clients didn't have a full opportunity to review all the documents to help prepare, to help educate the court in their affidavits, in their discovery, in their deposition transcripts, as to what this case was about and what happened. I mean, they want to keep pointing to the Johnson case over and over, and I understand it. I guess if I were on that side, I would too. I would say the Ohio Supreme Court has said such and such, and this is where this stands. But what they have done is they've made it so we can't defend against that, at least according to the trial court, because we didn't have the opportunity for my clients to prepare and their personnel to prepare proper affidavit testimony, proper deposition testimony as to what happened, why did this happen, all this and that. If you can't see the documents, you can't prosecute your case. Their theory was, of course, they told the trial court, you can't see the documents, can't prosecute the case. But Bruce Jenkins, the owner or partial owner of your company, president of the company, CEO, geez, he's a bad actor. He doesn't like us. Lawsuit. We have those all the time. He's going to say nasty things about us in the press. He's going to publish these things. You can put a court order on about that. You can put a court order. The judge can put a court order on. I'm involved in these all the time. There's going to be a court order on that any documents that are provided in this court case will be used in this court case. Instead, we have a situation where we were not able to share, we were not able to fully prosecute the case. The Ohio Attorney General made a determination that he believed, his office believed, his antitrust unit believed that this was an illegal action on their part, that what they did, the minimum pricing.
And that's in the record of this case?
Yes, it is. So they believed that, yet we were hands tied. We can't have the same information that the OAG has. We can't share that information. My clients can't pursue that information to a manner that they can explain it to a court as to what was happening. Yet the court previously found and said, first round through, you have standing, you have causes of action which are valid, you can pursue these causes of action, and then pulls the rug out at the end when my clients aren't able to explain in deposition and affidavit form why they have standing, why they have this themselves. They're not allowed to look at the documents. They're not allowed to do that. So And that was a major problem that caused, I think, a lot of this issue with the summary judgment. Otherwise, as I've indicated before, we are not conceding. We believe that summary judgment should have been granted to the plaintiff. We believe we pursued and we showed that they had an illegal price fixing. They conspired with the distributors. There were contracts that are in this case that were identified. They're in the record. It's not just that. I mean, they're trying to claim, and on deposition they claimed that, geez, we up here highlighting, we came up with this whole thing and we told everybody this is what you're going to charge. But when you read the contracts, no, it was an agreement. It was an agreement between each and every one of the distributors. I believe it was about 3 distributors, 2 that were mainly used by my client. But each one of those distributors agreed. They conspired with them to price fix.
And you have 5 minutes remaining.
Thank you. I was about to ask.
Good morning. Richard Hamilton on behalf of the Appalachian Highlighting International of North America, Inc. I'm going to refer to them economically as highlighting throughout the presentation today. May it please the court and counsel. I do think strongly that this is a very simple, straightforward case. I know you hear that from a lot of lawyers, but I spent 23 years with the Justice Department Antitrust, and this is a simple case. It has to do with standing, pure and simple. And the trial court got it exactly right. The appellant here, Aladdins Lights, has no standing under the Valentine Act, 1331.01 et sec, and it has no standing under its federal counterpart, the Sherman Antitrust Act, 15 U.S.C. Section 1. Those are the 2 controlling cases here that decide the standing issue, and the trial court got it exactly and correctly right.
Is it your interpretation of the trial court's order in this case that the plaintiff did not have standing by a failure to join certain parties? And that's the sole?
No, that's not, to me, that's not the soul. That's a nuance of it. The soul of the case, right at the core of the case is Illinois Brick, which is a U.S. Supreme Court case, and Johnson v. Microsoft, which of course is an Ohio Supreme Court case. I know you read the briefs, so you know what those cases stand for. They both hold together that an indirect purchaser has no standing, cannot bring an antitrust claim. Illinois Brick dealing with the Sherman Act, Johnson v. Microsoft dealing with the Valentine Act. That's the rule. And so unless there's an exception to that rule that gets you back in, then you're out. Right? You got nowhere to turn. And so the rule is if they're an indirect purchaser, they're out. Here, the evidence is undisputed, it's uncontroverted. Bruce Jenkins was asked, and the citation is found in the trial court's order, did you ever buy anything directly from Aladdin's, from Highlighting? And the answer was no. You didn't buy anything directly from them. They sold through distribution, through the distributors, of which they had 3, Hydrofarm, Sunlight Supply, and Bloomington Garden. And so they never bought anything directly from Highlighting, which makes them an indirect purchaser. What they try to do, what Aladdin's tries to do here, is they try to get back into the game, if you will, through the co-conspirator exception to Illinois Brick. And there are some federal courts that have recognized that. We briefed this issue extensively. I don't really have much to add to the briefing of the cases that support our position and our contention and the prevailing federal view as found by the 3rd Circuit, the 5th Circuit, the 7th Circuit, the 8th Circuit, and I believe the 1st Circuit, is that if there is going to be, if you're going to find a way to avail yourself as an indirect purchaser, which Aladdin's is here, to the co-conspirator exception, you have to name the middleman, that distributor, in this case either Sunlight or Hydrofarm, the 2 distributors that they purchased Portalux branded products from and through. They have to name them and join them as defendants, and here they didn't do that.
For standing.
For standing. And so if you don't do that, all the problems with apportionment and multiple recoveries and duplication recoveries that Illinois Brick and the Johnson Court were concerned about come into play. And so it's a simple procedural thing to do. All the plaintiff had, all the appellant had to do here was name Sunlight Supply and Hydrofarm, its 2 distributors in a lawsuit, and they wouldn't have had that issue. But they have that issue now.
Okay, help me understand some of the terminology that was referenced
Sure.
in terms of Aladdin being terminated. I understand Aladdin never was a direct purchaser.
Correct.
But I don't understand them being terminated from the ability when the response is, we won't sell to you at a high, at a price. I don't understand how those two things come together.
I'm glad to explain it.
Thank you.
There's a seminal case, United States versus Colgate, that was decided by the United States Supreme Court in 1919, so it's been around for a long time. And in fact, interestingly, and I don't want to jump things out of sequence, but it postdates the common pleas decision from Franklin County that Governor Attorney General DeWine referenced in a letter. I'll talk about that later. And so Colgate was a seminal case. It's bedrock antitrust principle that a manufacturer has an absolute right to set the prices, terms, and conditions under which it chooses to do business with anybody downstream. And what they did here, what my client, ELINA, did, was in order to protect its brand. I mean, it runs with the big dogs. I mean, it's an eye-lighting operation. It manufactures lights. It's a smaller outfit out of Mentor, Ohio. And the big dogs in this industry are General Electric, Sylvania, Philips, really big companies. And my client, ELINA, makes a product that it thinks is pretty good. But if it just falls into the rest of the pack, it's going to get swallowed up and run over. So they wanted to protect their brand, just like Rolex or Mercedes or anybody else does. And so pursuant to the Colgate doctrine, they're permitted to say, look, we'll do business with you, but you have to sell this at this price. And if you don't, we can terminate you. Colgate's pretty limited. What it allows a manufacturer to do is terminate.
I
We'll continue.
understand that.
Okay.
And perhaps it's just the use of the word that causes me pause. Because Aladdin's wasn't one of the distributors for eye lighting.
Correct. Correct.
So if they never bought, let me rephrase that. Did they never request to buy from one of the distributors one of these lights?
Aladdin's?
Did Aladdin's
Yeah, they
fail to request to purchase one of these lights from one of eye lighting's distributors?
Well, the policy, the Colgate policy was implemented in July of 2010. Prior to that, my understanding is that, my clear understanding, is fact, is that Aladdin's did buy Hortilux branded products through two distributors.
That's what I
From
was.
two distributors, yes.
Okay, because when we're going through the briefs, we're getting two different signals here on what the past history was. And I know, and I don't want to take up all of your time, it's
Right.
just, it's hard to get past to the rest of the argument when the facts seem a little bit.
Well, I'll take as much time as
No,
necessary. Your
no,
question's more important
Okay,
than anything else, I have.
You cleared it up for me, thank you.
Okay, thank you. And so the standing issue is pretty clear. And what the Johnson case made clear is really two things. Number one, federal law applies and governs the interpretation and the construction of the Valentine Act. That's an important concept. It's been the case in Ohio for many, many years, decades. But the Johnson court made that clear. And it's important because it really, all of the other arguments that have been raised by and litigated in this case all relate to that. Because the Valentine Act doesn't have the most robust history in the world, right? And that's because, it generally gets big-footed out by the Sherman Antitrust Act. So there's not a large corpus of Valentine-related cases. Most plaintiffs turn to the federal antitrust laws if they can, for a lot of different reasons, okay? But here, it's important to know that against this relative non-robust Valentine corpus of law, what the courts do look at is they look at federal law. And here our contention is clear. When you look at the co-conspirator exception and the prevailing view among the federal cases, that it's a no-brainer that there has to be joinder of the middleman. It has to be joinder here of Sunshine and Hydrofarm, the two distributors. And not having done that, they just don't have standing. And that's a simple proposition. doesn't require anything about the attorney-eyes only designations or what was or was not seen. I'll get into that near the back end. That was a prominent part of Mr. Lepp's argument today. But none of that AEO designation or process, which included a full hearing. I'll jump to that right now since I'm on it. I mean, there was some litigation. We sought on behalf of BioLighting a motion for protective order. There were over 10,000 documents that were produced, at least 10,000. I think it ultimately was several thousand more than that. And the court, in helping determine whether we designated 14 documents as AEO, which is pretty small pickings. And if you read the court's actual order, she talks about the process where both sides had full opportunity to address and discuss each of the 14 documents, which is what was done. And sometimes I wonder if Mr. Lepp was at a different hearing, but I remember having those 14 documents in front of me and going through each of those 14 documents. And there wasn't an evidentiary hearing. There was no need for that. The documents were clear on their face what they were. The court makes reference to that in her order. That these were highly price sensitive and confidential. They were the DNA blueprint for highlighting's pricing and its costs and its margins. And that's not the kind of thing that should be publicly available. And the court very shrewdly and very wisely decided, and it's found in her order, that if there's a problem, if one of the parties has a problem with that, then they can come back and they can request some modification of that. And as the trial, as the case proceeded to trial, if that's where it was going, she left open the idea that there's going to have to be some other arrangements made. And so this idea that somehow the appellant was not able to prepare its case and the decision here by the trial court was standing, right? It doesn't have anything to do with the merits of the case. I mean, there's nothing in those AEO documents that were designated that has anything to do with the standing issue. But the idea that Mr. Lepp, on behalf of appellant, couldn't go back to the court and say, look, we're really up against it, we really need to look at these, and here's why, and we're going to make the point and try to persuade the court. They could have done that. They certainly never did that. And I think the court touched on it very clearly and directly. I mean, there's no prejudice here. There's no actual prejudice. There's none claimed in the appellant's brief. And in fact, any claim of prejudice would run consistent and counter to one of the points that they pursue. They invite this court to not only find that standing is proper here, but that that the denial of their summary judgment motion should be overturned, and this court should find that summary judgment is actually and should be granted in their favor. So if they're pressing that argument, it's hard to argue that we were also prejudiced. To me, it's just illogical to say you're prejudiced, and yet also claim before this court that hey, we not only have standing, but we win. Trial court got it all wrong. You have to find in favor of us for summary judgment purposes on liability. Just a word about the co-conspirator exception. We talk about it at length in Appleby's brief, but the cases they cite, they just don't help them, and they're either irrelevant or they're extremely factually distinguishable. They spent a lot of time talking about, for example, United States v. Apple. That case had nothing whatsoever to do with the co-conspirator doctrine. The United States pursued that case as a straight-up horizontal boycott. There was no vertical price restraint that was challenged there. And the United States government did that in part because they wanted to be in the per se rules, not the rule of reason rules that control after the Legion v. PSKS case in 2007 that control all vertical price fixing agreements. They rely considerably on the Lowell case out of the 11th Circuit, but that case only involved a vertical price fixing restraint. And the court expressly in Lowell said that the indirect purchaser rule applies where both the vertical price fixing and a horizontal boycott is alleged. That's our case. I mean, they have two antitrust claims here. One's a vertical price fix, and the other is a group boycott. There's no evidence of either that has ever been produced to support those claims. But that's their claim, and so that makes Lowell highly inopposite. They also rely on Shamrock Foods. So Shamrock Foods involved, out of the 9th Circuit, a 1984 case, no pass-on issues. That's because there's a class action settlement that predated the litigation. And so all the risk of multiple or duplicative recovery was eliminated. And so that's not our case. Our case has potentially hundreds and thousands of retailers. It's got middlemen that have not been joined, that also have a viable antitrust claim if they were to choose to pursue it. And finally, they rely on the NRA ATM fees litigation, 686 Fed 3rd 741 out of the Ninth Circuit in 2012 cases. And I'm sure the court has reviewed that along with the rest of the brief, and you can see our argument there, and it's a clear one, is that whatever Shamrock Food stood for, that NRA ATM fees limited that very sharply, and in fact said that held that a co-conspirator exception applies only when the plaintiff has paid fixed prices. That's an interesting concept there. You know, in this case here, we are treating, for purposes of the Valentine Act, we are treating Aladdin's as an indirect purchaser. In fact, after the policy was implemented in July 2010, they're a non-purchaser. They purchased nothing. They purchased no Portalux products. So it's very hard to imagine how they could ever show damages. It's hard to imagine all the other things like antitrust injury and harm to competition as a whole, and all the other things and features that have been throughout this litigation.
And you've reached the end of your 15-minute time. Thank you.
We'll stand on the rest of our brief, and thank you for your time.
Thank you. I'll just use probably a minute or two of my time here that I've left. Just want to talk just very briefly about the group boycotting and vertical pricing, more about the group boycotting. We have evidence of both of these, especially the group boycotting in here, and that they are trying to pretend, and they are claiming at times in their transcripts, that we set the pricing and we set the rules of how this is. We're Colgate. We did this as Colgate. We have evidence that that's not what happened. We have evidence which we presented in the form of the contracts. We have evidence in the form of cross-examination of the witnesses that showed there was actually a conspiracy between them. It might have been Lighting's idea. I'm sure it was. But then again, maybe it wasn't. Maybe it was one of the distributors' ideas. But someone came up with this idea, and they contractually agreed. And the contracts are clear. And the testimony from the CEO and president of the company of iLighting was clear that it was a contractual agreement, that they contractually conspired and boycotted my client and others. Thank you.
Thank you both for your presentations this morning. We'll take a matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be accessed through the Ninth District Court of Appeals website. Thank you.
Thank you very much.